I will go ahead and call the next case. It's Comerica Inc. versus the Department of Treasury. This is a 20-minute argument per side. Mr. Thompson, you can reserve or try to reserve some of that for rebuttal. And if you're ready, you may proceed.
Well, thank you, Your Honor, and good morning. Assistant Attorney General David Thompson here on behalf of Treasury, and I would like to accept your invitation to take 5 minutes for rebuttal. By way of some background, this case concerns a partnered effort between public resources and private enterprise. Now, the tax statute at issue here, the Single Business Tax Act, both preserves and reflects that partnership, and it does so by way of certain certificated credits, which themselves seek to promote certain public goals. Now, those public goals are things like employment and investment in certain districts, but the SBT also had certain accountability measures built into it to ensure that both parties got the benefit of the bargain and that those public goals were met. Now, as to the mechanics of the SBT, it is a self-sufficient whole. It has all the necessary and sufficient ingredients built into it to both make these credits available and to restrict them to proper credit claimants. And for that reason, there is no grounds to look to other areas of law, whether it's foreclosure law, banking law, merger law, federal law, whatever the case may be, to answer the question before this court. Quite simply, the plain language of the statute provides that these credits can only transfer by way of assignment, and they can only be assigned once. Now, while Comerica asserts that this court cannot write additional language into the statute, and Treasury certainly agrees with that, the problem is that it's actually Comerica that wants to write certain words into the statute. Specifically, Comerica would have this court write the phrase by transfer by operation of law into the SBT. Of course, those words are not there, and for that reason, this court should decline that invitation. Thus, I propose the rule for this court to articulate as follows. As it concerns Michigan certificated tax credits, Michigan law is the exclusive authority for the awarding and claiming of these credits, and this rule preserves both the letter and the spirit of the SBT and the public goals that it seeks to promote. Now, on the question of the plain language, going back for a moment, Comerica effectively relies on an assertion that there is some kind of silence or ambiguity in the statute. We don't think that's true, but even if that is, this court recently held in Tomra that if there is ambiguity present in a statute, that statute must be strictly construed. Now, we don't think that doctrine necessarily comes into play, again, because of the plain language of the statute, but we do want to point out that that is a doctrine that comes into play necessarily just by virtue of Comerica's primary argument.
Mr. Thompson, let me interrupt you and see what questions folks have, and then you may continue. And I'll start with Justice Bernstein.
Hi, counsel. Good morning.
Good morning.
Again, you know my style. It's just try to keep it as simple as possible. And I'm going to ask you the question kind of, in a lot of ways, kind of contextually, kind of the way I asked the case before, a simple question, which is, in this situation, you have a merger. And ultimately, when you're trying to have a merger, or let's say in another analogous circumstance, you have a buyout or something, you know, the tax credits are an asset. They're a part of how you plan a business. They're a part of what you're buying, what you're acquiring. I mean, ultimately, in this situation, you know, for Comerica, as they kind of, you know, went forward with their business plan, and they, you know, are the entities that are kind of trying to work out the value of a business. I mean, wouldn't this make this incredibly complicated and incredibly difficult for one entity either merge or buy out another entity if once you bargain and you have an understanding for the value of that entity, it now changes? I mean, isn't this something where basically, you know, the Treasury is kind of putting forth an argument that could, in many situations, make it very challenging and very difficult to do the one thing that business needs to do, which is plan and assess value?
So, Your Honor, I think the answer to that question is no. And the first thing I'll note is that these are sophisticated parties, and they made certain strategic business decisions and should have been aware of what the Michigan tax code provided for, and they must accept the implications of that tax law. Now, whether or not it's a matter of complication or difficulty for those parties, again, they are sophisticated and they know the law. The other side of this is that in order for these tax credits to be administrable in the first place, you have two administering agencies. One of them is Treasury on the one hand, and the other is the MEDC, the Economic Development Corporation. Now, Treasury is responsible for essentially identifying what credits are available and who the proper credit claimant is. And in this case, Treasury could not know who the proper credit claimant was because you had a brand new entity with a new FEIN that they had never seen before. And so that's the trouble that Treasury has. On the other side of it, you have the same confusion with the MEDC because the MEDC had contracted with the initial qualified taxpayer. In this case, it's KWA1 LLC. And then KWA had then assigned these credits properly so to Comerica, Michigan. So MEDC knew who the credit claimant was and knew who the proper and knew the basis for the credit and how much of the credit remained. So I think on the one hand, we do want to make this possible for taxpayers. And if you look at
why does that matter? Like, so why does that matter? So it's I mean, there's a merger. I mean, why is that of significance?
Well, it's significant because first, the SBTA does not have any language about transfer of operation by law. If these parties had wanted to execute this merger and had wanted to take advantage of these credits, there would have been another way to do it if there had not been a prior assignment and if they had followed the procedural steps set forth in the SBT. And it matters because, again, these credits are designed to promote certain public aims. And if the two administering authorities don't have sufficient information to allow these credits to be claimed, then we're getting very, very far away from the eligible activity in the first instance, and then the amount of the credit on the other side of it. So
this, I mean, basically, I guess the question is that, again, I keep it simple. I mean, does it go down to basic equality and the essence of fairness and planning and protocols? That's kind of what I'm saying is that your answer to me is that they should have just known better because these are smart and sophisticated people. But because they're smart and sophisticated people, wouldn't they naturally have imputed the fact that, look, there's a merger taking place and this is just part of the assets?
Well, so the answer to your question would be presumably yes. And if you look at Exhibit D to the taxation section amicus brief, this section has all the information that you need. And what it shows is that these sophisticated parties, in fact, knew how to do this, Your Honor. So if you look at it, the very first item here is the tax credit assignment for the preservation tax credit. And it identifies the initial credit claimant, the qualified taxpayer, KWA, and then it identifies the assignee, which is Comerica Bank, Michigan, and then has the FEIN written in there as well. So they knew how to do this, Your Honor. They are sophisticated parties. They knew how to do this. They had done it previously. But the second time that they did it, they ignored all of those same steps that they already were aware of. So they are presumed to know the law, and their own actions show that they knew how to do it.
Counsel, thank you very much.
Thank you, Your Honor.
Justice Clement.
No questions. Thank you.
Justice Cavanagh.
Yeah, I was wondering, how do you respond to the point raised by Michigan Bankers Association that Comerica, Texas and Comerica, Michigan are the same entity?
So, Your Honor, I think that's a great question. And the fact of the matter is, while they assert that they are the same entity under merger law, that's really not the question presented before this court. Whether or not they're the same entity for purposes of corporate or banking law is one thing. The real question here is whether or not they are the same taxpayer for purposes of these Michigan certificated tax credits. And if you look at the merger agreement itself, the agreement and plan of merger make clear that these, in fact, were two separate entities. They had different FEINs. They had different states of organization, different places, principal places of business. So they are, as a matter of fact, they were separate entities, and they were so for 23 days prior to the agreement and the execution of that agreement. So that may be true as a matter of merger or corporate law, but it's not true as a matter of the governing statute here, which is the SBT.
Okay, thank you.
Justice Welch.
Yes, thank you. Mr. Thompson, I'm wondering, you talked about tax policy and obviously how that's sort of rooted in this case. I'm wondering how you respond to sort of the policy behind the brownfield credits. The plan is designed to clean up very expensive properties that have environmental contaminants and encourage parties to do that. Obviously, there was an entity that did that, and then transferred the credits to Comerica. I think Comerica was maybe a smaller party of that deal, and I think banks are often the entity that then gets the credits transferred to them. So I'm just wondering, does your position up into that in an age of a lot of bank mergers? And did the state kind of get their benefit in the bargain? And with that sort of up in the policy behind brownfield credits?
So, Your Honor, you're correct. There was an initial investment. So there was eligible activity, credit eligible activity, because there was that investment made by KWA1 LLC. And the policy, again, is going back to this question of a partnership. The policy is to make sure that there is a reconciliation of both the interests of the private enterprise, in this case, it's the investing entity, and also the public good. What we're suggesting to you today is that the more distance you put between the eligible activity on the one hand and the credit claimant on the other, the harder it is to make sure that that public policy is effective. And the reason for that is because Treasury and MEDC have to basically keep track of these credits and who the credit claimants are. And so in order to make this work, we need to make sure that we follow the statute. And the statute provides for two things in kind of the big picture. One is the nomenclature for who can take these credits, and the other is the procedure for how they're claimed and assigned. And I think the further that we get away from that, the more attenuated this question becomes in terms of making sure that the state, in fact, got its benefit of the bargain. And to make clear what the scope of this is. So what we're talking about here today is things like brownfield credits. And Your Honor, you make a good point. Did the state get what it bargained for? But I would suggest that there's actually a larger question here, which is certificated credits generally. And it's not just brownfield credits. There are mega employment credits. And these are the kinds of things that require year after year monitoring. In fact, if you look at a sample mega tax agreement with the MEDC, it talks about the company shall complete an annual application. So it's something that requires kind of an ongoing obligation, an ongoing commitment. So in this case, Your Honor, the state very well may have gotten that investment, but to ensure it got the benefit of that investment, but to ensure that the tax credits are limited, right, in such a way as to make this work, not only for this credit, but for all certificated credits, you really have to follow both the substance and the procedure set out in the SBT.
Thank you.
I see Justice Viviano, you have a question, but let me just go to Justice Zahra and then we'll come to you, Justice Zahra.
See to Justice Viviano.
Okay.
I'm sorry. I'm certain that I pressed that button on accident. Sorry about that.
Oh, okay. No, you don't have a question right now? Okay. Justice Zahra, did you have one?
Well, then I'll go back. I think you tried to respond to answer this question in response to Justice Bernstein, but I'm not quite sure I understand your position. Why should we view the transfer of the tax credits as an assignment here when all we have really is a merger agreement?
Well, Your Honor, so you don't necessarily have to look at it as an assignment, and that's okay. If there's no assignment, then the tax credits don't transfer at all, because there's only one mode of transfer, and that is by assignment. So if there was no assignment, then these tax credits began with KWA1 LLC. They were assigned to Comerica, Michigan, and they end there. So you don't necessarily have to see an assignment here. But if there's no assignment, there's also no transfer. But as to the question of if they can transfer otherwise than by assignment, our position is no, they cannot. And again, we look to the plain language of the statute for that. But even if you are to allow for some other mode of transfer, despite the fact that the SBT doesn't allow for any other mode of transfer, I still think that you need to look to the SBT in terms of the procedure for how these credits are claimed. The SBT is quite clear. You have to file a certificate of completion, a request for assignment, and these are all the kind of the procedural mechanisms that allow the two administering agencies to make clear who the credit claimant is, what the eligible activity was, how much of the credit remains after the prior credit claimant has used some portion of it. So even if you are to allow that that's the case, I don't think you can throw out the rest of the procedure that the SBTA gives us to, again, allow the administering agencies to do their work. But our primary position is there's no assignment and there's also no transfer, because again, transfer can only be effectuated via assignment.
Thank you.
Counsel, I think you kind of answered this to Justice Cavanagh, but let me try it a different way. What if Comerica had made the argument that there really wasn't a transfer at all. You know, these F reorgs under federal tax law, at least, don't trigger any tax-paying gains or losses. Comerica Michigan went into the dressing room, changed its clothes, came out as Comerica Texas, and there was no transfer. What if Comerica had said that? Would your position be different?
No. And before I answer your question, I see that I'm close to my 5 minutes here. So can I answer your question but still get my full 5 minutes?
Probably not.
Okay. Well, I'll answer your question.
Maybe for trying, you might get a little extra.
Well, I will venture a quick answer. No. And the reason is, first, federal law does not apply. But second, even if it did, there was no F reorganization here. You'd have to show an identity of tax incidents, property, and tax and stocks as well. And in this case, if you look at the facts here, there's not an identity of stocks. In fact, there were certain prior Comerica Michigan shares that were canceled. And so there's no identity there, even if you accept that the federal F reorganization provisions come into play. As a matter of fact, there was no F reorganization because they can't show the identity of interest between the two parties. And I will reserve the remainder of my time. Thank you.
Before you do that, counsel, I guess I do have one question. Since we're talking about what law applies in this case, at an earlier stage, I think maybe the text, at an earlier stage, there was, I think Texas law was applied to the merger. And as the case has proceeded, the Court of Appeals applied Michigan law. The parties don't seem to be disputing what law applies. So is it your position that Michigan law would apply to this merger and helping us determine, for example, whether there was a transfer by operation of law? Or is it your position that it doesn't matter what law applies?
Our position is that it does matter what law applies, and the specific law that applies is the SBT, the Michigan tax law. So Michigan banking law or merger or corporate law, there's no explicit reference to that in the SBT, for which reason there's no reason to look to it. So our position is quite clear. It's Michigan tax law, and in specific the SBT, that governs this case.
Okay, and if we disagreed with you and thought that Michigan or the corporate law that govern this merger might have something to do with this case, would you think that it would be Michigan law that applies to this transaction or Texas law?
Well, Your Honor, as a general proposition, I believe that Michigan law should resolve Michigan disputes. I don't think there's any reason to apply Texas banking law. Here we're talking about a taxpayer seeking Michigan tax treatment. So I would reject that Texas law has anything to say about this.
Okay. Thank you, counsel.
All right, 228, you're reserving it.
Thank you.
Mr. Bruetsch, and I apologize if I mispronounced your name. You can correct me.
Thank you, Chief Justice McCormack. Thomas Bruetsch, hearing on behalf of Comerica Bank. And I guess I will start by addressing Justice Viviano's last question on Texas corporate merger law versus the Michigan bank merger statute. And I think the answer to the question is, I believe Michigan law applies for the reason I'll get to in a second. But for a substantive result approach, I don't think it matters. The Texas statute, which is Texas Business Organization Code 10.008, has different language, still pretty broad, does use the word property, and we'll get to whether this is a property right or not in a moment, whereas the Michigan statute is probably a little broader. But the Texas cases I've looked at, and there's at least 4 of them, all use property tax credits in the context of an intangible property right. And so I think Texas courts, even though there's no holding on that point in Texas, there's just statements made in cases. I think Texas would define a property tax credit as an intangible property right. And therefore, regardless of the statute that you apply, whether it's Michigan law or the Texas Business Corporation Merger Act, I think you're going to reach the same result. I do think, though, that the Michigan Bank Merger Act is the right one here, and it's for this reason. If you look at the definitions of the state in the statute, when the legislature is discussing what happens in a merger of banks in Michigan, the definitions of what a consolidated bank is or what a consolidated organization is under the statute includes an out-of-state bank. And so the statute expressly contemplates the situation we have here, where an in-state bank merges with an out-of-state bank, and the references in the statute are to either the consolidated bank or the consolidated organization. And that's why I think the Michigan statute applies here. And that's 47.13703. This case does involve kind of a four-way intersection. It's a four-way intersection between tax law under the SBT, but also under the corporate law, and in particular the merger statute, but also concepts of property law and contract law. And you can't just look at tax law and put it in a silo and pretend that the other law doesn't exist, or pretend that the federal tax law, which is more developed than our law, given its scope, doesn't exist. And if you look at these other bodies of law, I think it really clarifies the questions for the court. There's really no question under the Michigan bank merger law to address a question that was raised earlier, that Comerica, Texas and Comerica, Michigan are the same bank and the same entity. I think that the tax section made that point. The Michigan Bankers Association made that point. Texas, the new bank, as the Department of Treasury calls it, which is Comerica, Texas, and Comerica, Michigan are the same bank. And that's right out of the statute. The statute says, quote, the corporate existence of each consolidating organization is merged into and continued in the consolidating bank. The U.S. Supreme Court said the same thing in the Helvering case back in 1939, that the transferor is drowned in the personality of the transferee. And I think that's one of the central concepts going forward in corporate law. And the Michigan statute says the consolidated bank, which is the consolidation of the out-of-state and in-state bank, possesses all the rights, interests, privilege, powers, and franchises of the consolidating organizations. The SBT Act does not answer the question of what happens in a merger. The SBT Act prohibits a second assignment of tax credits, and that's all it does. It doesn't say that's the only means of transfer. It doesn't talk about mergers or other means of transfer. And just because it's silent on that point doesn't mean it's precluded, especially when you have other statutes and other bodies of law that relate to the same subject matter, in this instance, transfers of assets, transfers of property, rights, privileges, whatever you want to call them. You have, in this case, two statutes that deal with those. They don't conflict. They're not ambiguous. One allows rights to be assumed, and I don't think they're transferred. I don't think they're assigned, certainly. They're assumed by the resulting company in the merger.
Counsel, let me interrupt you and see what questions people have. So we have time to get to them. Justice Bernstein.
Yes, Counsel, good morning. If you could respond to Brothers Counsel's contention that the parties could have done this a different way but chose not to.
Well, the parties couldn't have done this a different way. Thank you, Justice Bernstein. Obviously, we agree that there's only one assignment allowed under the law. And so there is no provision for a second assignment. There is a provision, though, in the Michigan Banking Act for mergers and assumption of rights and other interests through the benefit of a merger. And we know and understand as a matter of corporate law that you have asset sales in which only certain assets or maybe all assets are plucked without liabilities being transferred. And you have mergers, and they're completely different bodies of law. And we accept that. We accept the notion that you can buy certain assets of a company in an assignment or a sale without getting liability. Here we have a merger, which is just a different form, one that's allowed by statute, one that this court has determined arises out of operation of law. And in that case, we're also transferring the liabilities. And so Comerica, Texas, or New Bank, as they call it, has tax obligations to the state of Michigan. But they say, well, even though you have the tax obligations because you took advantage of the merger statute, you don't also get the tax credits, even though federal authorities, the IRS, and virtually everyone else would deem you as the same continuing entity with the same employees, the same books and records, the same obligations, the same liability, but for some reason not the same tax credits. And that doesn't make much sense.
Thank you, Counsel.
Justice Clement,
No questions. Thank you.
Justice Cavanagh.
Mr. Bruetsch, good morning.
Good morning.
I have a question. Given your position, consistent with what's been raised by MBA, that Comerica, Michigan, and Comerica, Texas are the same entity, why did the parties or why did you stipulate that in the tax tribunal that Comerica, Michigan ceased to exist? And regardless of, I guess, maybe why, what do we do with the fact of that stipulation?
Well, I think that's just, Justice Cavanagh, a function of how the merger statute works. So you have, and I'll agree with this point with Brother Counsel, you have an entity existing, Comerica Bank, Michigan. You have an entity that's formed to be the entity that is the resulting merged corporation. The two entities get pushed together. As a matter of law, I think it's correct to say that Comerica, Michigan, as that bank, ceased to exist. Its form, its function, and everything about it was pushed into this new organization, Comerica, Texas. And so its corporate existence in Michigan is a matter of process, procedure, law, however you want to call it, doesn't exist. It doesn't have its domicile here anymore, but it does maintain all of its corporate functions, corporate liabilities, and responsibilities as just a part of the new entity. So I think it's consistent that, yes, you have a new entity, Comerica, Texas, domiciled in Texas under the regulation of Texas banking authorities and no longer under the regulation of the Michigan banking authorities, and still call it the same bank, even though Comerica, Inc., Detroit, Michigan no longer exists.
Okay, thank you.
You're welcome.
Justice Welch.
Thank you. Counsel, I'm wondering, one of the things that Mr. Thompson brought up was sort of this challenge for the state when a merger like this happens. You know, how do they keep track of sort of the records and what's the proper credit, given that it's on paper going to look like a different entity?
Yeah, Justice Welch, I think that's mostly kind of overstatement. Obviously, this issue came up here. There was correspondence between the parties. Comerica, Texas, is owned by Comerica Incorporated. Comerica Incorporated is actually the taxpayer in this case. So Comerica Incorporated has subsidiaries. One of those subsidiaries was Comerica, Michigan. It merged that subsidiary into Comerica, Texas. The identity of the taxpayer never changed. It was still Comerica Incorporated, taking tax credits on behalf of its subsidiary, Comerica, in this case, Texas now. But the returns and the correspondence, all of these things inform the department when we actually go and take the tax credit, who we are. And it's also a little bit of a red herring in the sense that the work is completed. The benefit of the bargain to the state has occurred. The certificated credits themselves don't get issued until the performance that entitles one to the tax credits is complete. The contract has been satisfied. And so to go and then say, well, you know, we couldn't figure out and we have this administrative hurdle, that's really not true. The work is done, the credits are issued. It's just a matter of applying them on the tax return, which we do, and then it's resolved from there. So I don't see this as some administrative nightmare, nor do I see it as something that should essentially wipe out the provisions of both the corporate statutes and the SBT.
And I wanted to follow up to Mr. Thompson alluded to, obviously, there are tax credits for many, many things. So I certainly recognize this case has implications beyond the super specific tax here. We know the MEDC, there's credits for job creation. I believe those obligations often extend out over many years, and sort of evidence has to be presented that they've met those obligations. In this case, do you still have ongoing obligations with regard to this particular project?
I believe the answer to that is no, because the certificates have been issued. I have not seen anything actually in the record on that, but my understanding of how the process would work would be no. It's not something that's an ongoing obligation. It's performance completed and then certificates issued. And I know the tax section went into some detail in that in its amicus brief. And I think, you had addressed the policy implications as well. And I think the policy implications were really very well addressed in the case we cited in our brief called International Paper versus Broadhead. That's an Alabama case, very similar on the facts, except there were two murders involved in that case, and the Treasury officials tried to extinguish the credits. And that court in Alabama really did look at the policy, but the policy that it focused on was the encouragement of the investment and the idea that, especially once performance has been given, that to go back later and try to extinguish the credits and get the essentially windfall for the government of having encouraged this activity and then taken it away despite nothing in the statute providing for that would be unjust. And I think that's the policy implication that this court should focus on.
Thank you.
Justice Zahra.
I have a little bit of a problem understanding why we're focusing on merger as opposed to assignment. I know you say it occurs by operation of law, but why is it that we first look to the merger law as opposed to just the assignment law?
Because that's not what occurred here, Justice Zahra. We didn't have an assignment. And I think that an assignment is defined in a very particular way. And the assignment is what is the word the legislature used when it was saying you can't do this a second time. Legislature could have used different words, different language, could have been much broader, but it chose to use the word assignment. And this court's defined what an assignment was. It did that in the Kim case and distinguished what an assignment is from a transfer or an assumption by operation of law. And discussed in that case, and certainly the Court of Appeals followed it up in other cases, the distinction between what happens in a merger and what happens in an assignment. We did not buy these credits. Comerica, Texas did not buy these credits from Comerica, Michigan. They didn't do an assignment. They didn't do an agreement. They didn't do any of the things that you would expect when there's an assignment. What happened was there was a merger, and everything that Comerica, Michigan had an interest in moved over to Comerica of Texas, including all the obligations and liabilities. And so that's the fact of what happened. There was a merger and not an assignment. And that's, of course, why we focus on the merger aspect, because that's the transaction that occurred.
Thank you.
You're welcome.
Justice Viviano.
No questions.
Counsel, you have a little bit of time left if you would like to continue.
Thank you very much, Justice McCormack. I think that I'll just touch on the property right question that really was, I think, one of the main things that the court focused on in its order granting leave. And whether or not, and so the Court of Appeals obviously did find that there was a property right or a vested property right in the tax credits for Comerica of Texas. I don't think that's necessary for the court's decision today. I don't think it's a necessary part of the Court of Appeals holding either. But I think there really are two complementary analyses that support the conclusion of the Court of Appeals. The first was the Court of Appeals' own analysis, which was more of a property rights analysis that the cases it cited discussing what a legitimate claim of entitlement is versus a mere expectation. It is really complemented by the tax section's amicus brief, which focused more on contract rights, because, of course, these are rights that were given to Comerica's predecessor by the state of Michigan through contract. And, the question arising as to how can you impair those contractual rights. And I think those two property analysis, the property analysis done by the Court of Appeals and the contractual analysis done by the tax section really fit hand in glove together. If you have a contractual obligation of the state and the parties to the contract have performed it, how can you then go back and impair that obligation? Similarly, on the property side, when you have a contract like that and it's been performed, you do have a legitimate claim of entitlement. it's not a mere expectation. And so that's why I think the Court of Appeals was right on that issue. If there are no other questions, I would cede the rest of my time.
Thank you, counsel. Mr. Thompson, you have a little bit of rebuttal time, not as much as you wanted.
Thank you, Your Honor. So I'll try to get through this quickly. So first, on the question of bringing in other areas of law into the question of tax law. So I do believe this would be an issue of first impression in this state, but other states have looked at this and specifically found that corporate law treats a very different topic than tax law, and the two can't really be read in pari materia for that reason. And I offer for the court's reference the citation 140 NJ 523. That's a New Jersey case. There's some other cases out there that say the same thing, but I'll just throw that one out there very quickly. On the second question, to Justice Welch's question about how to administer this, the problem, so Brother Counsel, I kind of characterized our representations as an overstatement. The problem with this, though, is that when this merger happened, there was no notice to MEDC or Treasury at the outset. Essentially, what the taxpayer did here is they did what they wanted to do. They listed the credit in their return that they wanted, and then asked for forgiveness after the fact instead of permission on the front end. And even if that's permissible, which we don't think it is, you would still need to know how much of the credit remains. And just putting something in the return doesn't tell us, okay, who the prior credit claimant, how much did they take, how much is left? So there is a problem of administration here. And if you don't honor that, effectively what you have is a credit marketplace, which I think is what this statute was designed to prohibit, is not a free marketplace, but instead a very specified class of credit claimants. We are not extinguishing credits. So KWA, LLC, and Michigan Bank could use these credits in accordance with the agreements and their own filings. And they got the benefit of that. They made a business decision that Treasury had nothing to do with that obviously had different implications under Michigan law. As to the question of property rights, there are conditions precedent attached to these credits. In specific, you have to follow the statutory requirements, notice of completion, those kinds of things. And if you don't satisfy those conditions precedent, all you have is a unilateral expectation, which is effectively what Comerica, Texas has here. So I don't think the property right analysis really helps us a lot in this case. And if there are no further questions, I will close just by noting the rule that this court, we believe, should articulate is about Michigan certificated tax credits and Michigan tax law being the exclusive authority, therefore. Thank you very much.
Thank you, counsel. Let me make sure there are no follow-up questions for you. Any follow-up questions for Mr. Thompson? Thank you both. The case will be submitted.
Thank you.
Thank you, Justice.